Not only did he reinstate a third-degree murder charge, not only did he refuse the defense's request to transfer the trial out of Minneapolis, but now he's basically barring the defense from being able to admit testimony from the drug dealer who was in the car with George Floyd. All that seems, frankly, extraordinarily pro-prosecution. This brings us to the latest in the Derek Chauvin trial. So the Derek Chauvin trial continues apace. The defense began laying out its case yesterday, and it was basically two pieces of testimonial evidence that really mattered in the defense case with regard to Derek Chauvin yesterday. Now, listen, if I have to ballpark where I think this is going, I don't think there's a chance in the world that Chauvin actually gets acquitted. I think that given the nature of the jury, the fact this is taking place in Minneapolis, I think it's very doubtful. You need a unanimous jury to either convict or to acquit. So I think the most likely outcome here is a hung jury. I think you'll get a couple of jurors who say, we're not going to convict on the basis of this evidence. You might get a conviction on the basis of the manslaughter. I think that the murder charges are way too far. I think they were always way too far. I think manslaughter is, at the very least, somewhat understandable coming from the jury. Maybe, if you view the evidence through a very skeptical prism toward the defense. Okay, but I think the most likely outcome here is a hung jury. So there were two pieces of evidence that were trotted out yesterday with regard to the Chauvin trial. Piece of evidence number one was this old arrest in 2019, because it looks a lot like the arrest that happened in 2020 with regard to George Floyd, an arrest during which he died. His behavior during one is sort of indicative of his behavior during the other. The other piece of evidence was a bunch of testimony from a police use of force expert named Barry Broad, who basically testified that Chauvin's use of force here was reasonable. Okay, well, that is what the defense needs to show. Broad's testimony, I will say, was not stellar. The body cam footage from the 2019 arrest is more probative. Okay, so we're going to go through all of that, because remember, what the defense has to show here, or what the prosecution has to prove and the defense has to debunk, is one, that Floyd died of not a drug overdose or any underlying condition, but died because of what Chauvin did. And two, the defense, the prosecution has to show that Chauvin's use of force was objectively unreasonable, that it was unlawful. Okay, so the defense has to show, contrarily, that it's not beyond a reasonable doubt, that it could have been reasonable use of force, and two, Floyd could have died from these other causes. Okay, and that's what a lot of the testimony was about yesterday. Okay, so we begin with the 2019 arrest. There were a couple of pieces of testimony here that actually mattered. One was the actual body cam footage from the 2019 arrest, in which it was shown in court that Floyd had swallowed evidence when he was arrested, presumably drugs. That's what you swallow. I assume it wasn't like a bag of cash. He swallowed some of the evidence. And the idea here, presumably, is that Floyd could have done the same thing here. That as the cops were approaching, he put a bunch of pills in his mouth. Those pills drove up his heart rate and then drove his heart rate down, and then he died. Right? That would be the case that the defense is making here. They're saying he did the same thing as in 2019. It just went a lot more wrong in this particular case. And there's some ancillary evidence to that effect, namely that there were spit out pills in the back of the cop car that were laced apparently with meth and fentanyl. Here is the flashback 2019 tape from George Floyd's arrest back then.
There you go, right there. All right,
Put your hands
okay.
on top of your head.
What y'all doing?
Put them on your head. Top of your head.
Okay, man.
Open your mouth. Spit out what you got. Spit out what you got. I'm going to tase you. Spit it out. He's eating.
Don't you jerk away from me.
That was one yellow pill.
Put your hands behind your
That was one yellow pill, boss.
Okay, now slowly come on out.
Damn, man.
Hand on your head.
Put your
hand on your head.
Okay, so he obviously was not complying with officer orders there. He tried to swallow the evidence. And so what the defense was claiming is he did the same thing here. Michelle Mosing was a paramedic in that particular case. And she said that I talked to Floyd. And Floyd said at the time that he was addicted to pain pills and he took 7 to 9 Percocet. That is a lot of Percocet, gang. Right? Percocet is basically just OxyContin. Here's the paramedic in this particular case.
He told you that he swallowed some pills, right?
Yes.
Approximately 7 Percocet, correct?
I documented, 7 to 9 every 20 minutes or so for a while.
So he told you that he had been taking those pills throughout the day, right?
Yes, and I asked him why. He said he's because he was addicted.
Okay, so the drug addiction case is going to be a case that is pushed pretty heavily by the defense in terms of the causation. Again, there was an intervening cause. They're going to say the intervening cause was Floyd's dramatic drug use. The intervening cause was Floyd's heart condition. Now, one of the things that's happening here also is the prosecution is forcibly attempting to suppress witness testimony. So the defense argued in front of the jury, guys, his drug dealer was in the car with him. The prosecution could offer that guy immunity in return for his testimony. They won't do it. Why do you think they won't do it? Could it be because he's about to testify that he is complicit in the death of George Floyd by giving him a bunch of drugs in the car? Because why else would you have your drug dealer in the car with you? Right. So that's something the defense is arguing. They're also pointing out that there's other testimony that this guy had, for example, an FBI interview for like an hour and a half, and none of that testimony is being admitted in court. There are going to be some cases on appeal here. The judge's behavior in this particular case, I have to say, is extraordinarily pro-prosecution. Not only did he allow a week of testimony of very little probative value, probative means actually goes toward proving the case, he allowed a week of testimony from bystanders talking about how upset they were by Floyd's death, which is not probative in any way, it is just prejudicial. Not only did he do that, not only did he reinstate a third-degree murder charge that certainly does not fit the elements here, not only did he refuse the defense's request to transfer the trial out of Minneapolis, where it's very difficult to get a fair trial, but now he's basically barring the defense from asking questions about excited delirium to prosecution witnesses. He's barring the defense from being able to admit testimony from the drug dealer who was in the car with George Floyd. You know, all that seems, frankly, extraordinarily pro-prosecution. Okay, so the other piece of evidence that came out in the Chauvin trial yesterday was the police use of force expert. His name is Barry Broad. I don't think he did a fantastic job, frankly. He was trying to argue that Chauvin's use of force was justified. And there's a good case to make that his use of force was justified. Here was Barry Broad saying that Chauvin was justified in his use of force using a three-pronged analysis.
So was the officer's use of force proportionate to the level of resistance demonstrated by the suspect?
Objectively reasonable, correct?
Yes.
All right. So in terms of your three-part analysis, did you apply that analysis to this case?
I did.
In your opinion, was this a use of deadly force?
It was not.
And can you just briefly overview your opinions in this particular case?
I felt that Derek Chauvin was justified and was acting with objective reasonableness, following Minneapolis Police Department policy and current standards of law enforcement in his interactions with Mr. Floyd.
So the three-pronged analysis that he used to determine this, he said if the officer had justification to detain the suspect, which he did, how the suspect responded to the officer, and if the officer's use of force was proportionate to the level of resistance demonstrated by the suspect. It's that last one, whether the officer's use of force was proportionate to the level of resistance demonstrated by the suspect. That's the one that's really at issue, because it's clear that Floyd was resisting arrest. It is clear that the officer had justification to detain the suspect because the suspect was passing counterfeit bills and resisting arrest. The real question is whether Chauvin was justified in keeping Floyd face down and then staying on him as he passed out. Here's Broad explaining why he thinks they were justified in keeping Floyd face down in the first place.
Why would it be safer for the suspect to keep him in that prone control?
Because if they were to get up and run, handcuffed, trip and fall, sustain facial injuries, other injuries on the ground, their mobility is reduced, their ability to move is reduced, and the ability to hurt themselves is reduced.
What if they became sick, for example?
Prone control, instead of having somebody lay on their back where they could aspirate on vomit, prone control, their face is down, airway is clear. If they vomit, it's not going to go down their trachea or down their throat. Okay,
so that's actually a pretty good piece of testimony in favor of the defense, that what Chauvin was doing here is basic police protocol. Where this witness really screwed up is he said that was no use of force. That when you're suppressing Floyd by being on his back, that is a no use of force. That, of course, is very silly. It is a form of use of force. It is just a very low-level use of force is what he really should have said. And the prosecution, of course, jumped on this with both feet.
A compliant person would have both their hands in the small of their back and just be resting comfortably versus like he's still moving around.
Did you say resting comfortably?
Or laying comfortably?
Resting comfortably on the pavement.
Yes.
At this point in time, when he's attempting to breathe by shoving his shoulder into the pavement.
I was describing what the signs of a perfectly compliant person would be.
So attempting to breathe while restrained is being slightly non-compliant?
No.
No.
Okay, so there the prosecution is honing in on what they think is the defense use of force experts' overstatement of the case. What the defense use of force expert was attempting to say, presumably, is that if Floyd had been compliant all the way throughout, he would not have been kicking at the officers. He would have not been attempting to push against the officers. He would have been lying there, and then they basically would have just been either sitting on top of him or not sitting on top of him at all. Okay, here's the bottom line. Again, the defense does not have to prove that Chauvin is innocent. They just have to prove not beyond a reasonable doubt. The prosecution has to prove beyond a reasonable doubt. So we'll see what the rest of the witness testimony tends to show. Again, my guess is that Chauvin ends up convicted of manslaughter if he's convicted of anything. And a hung jury is a not implausible outcome in this particular case. If there's a hung jury, there'll be rioting, extraordinary rioting. If he's convicted of manslaughter, there may be rioting because people will just say, well, he should have been convicted of murder. And this is how the media have set up this narrative. Even though the evidence here is quite shaded, even though this is a much more complex story than people were originally led to believe, the media have set this thing up for riots. And riots you shall receive, because we now live in an America in which police killings that are unjustified are statistically extremely rare. They are very, very rare in the United States, given the number of interactions between police and suspects. But you know what is not rare? Whenever there is a controversial situation caught on tape, or even not caught on tape, between a white police officer and a black suspect, you can be assured that in at least 50% of cases, I would imagine, there is some form of rioting or looting that breaks out into the public. If it's high profile enough, that whenever one of these things becomes public, there is rioting and looting. And we should not live in a country where we expect that sort of behavior, because American citizens have a right to expect two things that don't conflict with each other. One, that they are not going to be unjustifiably killed by the police or mistreated by the police. And two, that their fellow American citizens should not be allowed to roam around looting and rioting and doing great violence and harm. These are not conflicting ideas. They're perfectly in consonance with one another, but the media have set them up in complete opposite to one another, because the idea is that if the cops do something wrong, then riots and looting, if not justified, are at least understandable. And that's the way the media have been covering this stuff throughout. That is the soft bigotry of low expectations. It would not be allowed under any other rubric in American life, but the media have basically decided, as Nicole Hannah-Jones said, 1619 riots. Facts don't care about your feelings, and it's a fact that The Ben Shapiro Show is the largest conservative podcast in the nation. Be sure to hit the subscribe button to stay up to date on all of our content.